Welcome everyone to our webinar on safeguarding vulnerable clients, mandatory reporting in NDIS and in-home aged care. My name is Astrid and I'm a senior lawyer at LegalVision, and I'm joined today by Martina from CareCFO. Martina, would you like to introduce yourself?
Thanks, Astrid. So as Astrid's mentioned, I'm the General Manager at CareCFO. I'm really excited to be presenting as a co-host with LegalVision today. My background is strongly in psychology and HR, but we work very closely in the care sector space. So enjoy today's presentation.
Before we begin, just a couple of housekeeping items. We'll send you a recording of today's presentation by email. You can submit your questions in the chat box and we'll answer them at the end. And please complete the feedback survey after the webinar. We also offer complimentary consultations for today's attendees. If you would like to claim, please fill out the survey and you could receive a consultation within the next 48 hours. So without further ado, this is today's agenda, which is set out on this slide. And we'll now just go straight in to your reporting obligations. So basically, who needs to report? If you're a registered provider, you need to comply with the NDIS quality and safeguard rules. And there's a list of reportable incidents, some of which have to be reported within 24 hours. And in case of restrictive practices, you have 5 days. What actually needs to be reported? For something to be reportable, there needs to be an incident, and it has to have happened or be alleged to have happened in connection with the provision of supports or services. This includes the death of a person with disability, serious injury of a person with disability, abuse or neglect, unlawful sexual or physical contact, sexual misconduct, and also the use of an unauthorized restrictive practice. But what does it mean to be in connection with the services? If something happens and you just, or your staff just happen to be there, do you have to report it? Do you have to report it if you observe something? And the answer is not clear-cut. The NDIS guidelines will actually give you some example of what needs to be reported. For example, if you have written a care plan and a person is injured while you are following the care plan, whether you're there or not, that is still in connection with the services. However, if someone is injured in the community, and it's not due to something your staff have done, but for a third party, for example, you've taken someone go-karting and they're injured while they're go-karting, you may not have to report that. On the other hand, there are additional reporting obligations, which you may be a mandated reporter at the state level, regardless of whether this is a reportable incident under NDIS. And I will go through this later. Unregistered providers. Technically, unregistered providers do not have to follow the rules, and they do not have any mandatory reporting obligations set out by the rules. However, there is a code of conduct, and the code of conduct says that any unregistered provider has to make sure that they take steps to act on concerns about any matters that may impact on the quality and safety of supports that are provided to a person with disability. And they must take all reasonable steps to prevent and respond to all forms of violence, exploitation, neglect, and abuse of people with disability, as well as to prevent and respond to sexual misconduct. This is incredibly broad language. What is a reasonable step to take? How can you prevent exploitation and neglect? What do you have to do? In this case, we formed the view that one of the first steps you can do is actually report it, whether it's to the NDIS Commission, to the police, or to the Elder Abuse Helpline, Child Protection Services, if you're working with children. You would also need to make sure that you have systems in place to guide your staff about what must and must not be reported. What is abuse? One of the things that you will most likely have your staff come to you about is this abuse? Do I have to report this? And also, as part of your incident management system, which I'll go through in the next slide, you need to make sure that your staff is trained to recognize abuse. Some of it is very obvious, bruising, broken bones, but others is more subtle. You may have clients who do not use mouth words, who are non-speaking, who do not have a functional means of communication. There's a change of behavior enough to indicate abuse is a change in their demeanor around someone, an indication of abuse. Those are all matters that you would have to train your staff to do and have guidance to help them navigate those situations. How can you report? Well, if you're registered, you can report to the NDIS Commission through the portal. What happens when you report just depends on what you are reporting, whether it's due to negligence on your part, in which case it might trigger an inquiry or an investigation, or if it just happened that the person got injured while receiving the services, in which case it's just recorded and nothing else comes out of it. The Commission can enforce a number of regulatory actions. They can issue an infringement notice. They can issue a compliance notice, and there can even be civil penalty through court. Participants can also institute abuse processes for assault if there is someone is injured while receiving the services due to the lack of care. Now, unmarried comes to mind, in which case there was a sole worker, and what needs to be done from an agency perspective or provider perspective is to follow the sole worker guidelines that have been published by the NDIS, including making sure that you check in with anyone who's only receiving services from one person from your agency. This is a reasonably difficult area to navigate in a seminar because it varies from state to state, but I just wanted to flag that in some states, all disability workers are mandated reporters of child abuse. In some states, all adults, irrespective of who they are mandated reporters of family violence, but not in others. So in addition to your NDIS obligations, you have to make sure that you're aware of your obligations under the state legislation, that you report family violence, sexual abuse, child abuse, if you come across it. And there is no nexus to connection to services. You may be a mandated reporter if you're providing services to a grandparent, but you suspect abuse of the grandchild from their parents. So it is quite important to read the legislation, get on top of your obligations, and seek legal advice should you need it. The other thing that comes to mind is privacy and confidentiality. If someone is injured, can you pick up the phone and call their next of kin? Can you let them know? Do they have to consent to this disclosure? And again, there is no clear-cut answer. It depends on whether the participant or the person injured has legal capacity, if there has been a guardian that's been appointed, if the person is at immediate risk of harm, and whether they have already filled out an informed consent form nominating someone to be contacted. Generally speaking, if someone has legal capacity and is able to make decisions, is not at immediate risk of harm, you cannot just call a family member to let them know without their consent. You would need to ask them, are you okay that I call your next of kin? If there is no informed consent already in place. The next step to make sure you're meeting your obligations is to have a very robust incident management system. And this applies whether you are registered or not registered. What your system has to do is to provide your workers and management with guidance about what needs to be reported, how to report it, and what to look for. Clear reporting lines have to be set out. You also need to appoint an authorized reportable incidents approver and an authorized reportable incidents notifier to make the notifications on the portal. Your incident management system must make it clear how the incidents are identified, how they're managed, they're reported, if needed, how they will be investigated, and also how they will be classified. The system must be robust enough that all incidents are reported, regardless of whether you have to report them to the NDIA Commission. This is because sometimes a single event of abuse may not constitute abuse. For example, if a support worker was used inappropriate language once, it may not cause physical harm, serious harm to be reported. But if it's a pattern of abuse, which could cause psychological harm in the long run, then this may need to be reported, which is why having a system that reports every single incident that is reported is critical. How you set up your system and what has to go into it will depend on factors such as the size of the provider, and also the type of services you provide. For example, if you're implementing restrictive practices, your system will be more robust than someone who's only doing community access with low-need participants. While we're talking about restrictive practices, I will now pass on to Martina, who will give us some really useful examples about what a restrictive practice is and how to handle them.
Thanks, Astrid. So it's really crucial to grasp the concept of restrictive practices. According to the NDIS Act, a restrictive practice, it encompasses any method or intervention that curtails the right or freedom of movement of individuals with disabilities. So restrictive practices encompasses in various forms, including seclusion, so isolating an individual from others in a confined space, physical restraint, so using force to restrict a person's movement, mechanical restraint, employing devices or equipment to limit a person's mobility, chemical restraint, administering medication to control a person's behaviour, in addition to environmental restraint, which is modifying the environment to confine or restrict a person's movement. Guidelines outline in the restrictive practices and behaviour support, so the NDIS rules, they emphasise that restrictive practices should only be employed under specific circumstances. So, for example, as a response to a genuine risk of harm to the individual with a disability or others, and only as a last resort. The application, it must be authorised in compliance with the relevant state or territorial legislation and or policy. And finally, the restrictive practice should be proportionate to the level of risk posed and employed for the shortest duration possible. Moving across now to the next slide, if you may. Thanks, Astrid. It's crucial to understand that any use of regulated restrictive practices must be reported to the NDIS Commission without delay. All plans containing regulated practices must be lodged as per regulatory requirements, and monthly reporting through PRODA is essential, with the frequency increasing to fortnightly if you're located in South Australia. Lastly, it's imperative to report any unauthorised uses promptly. This proactive approach, it safeguards the well-being and rights of individuals with disabilities, ensuring that support remains dignified, respectful, and in line with regulatory frameworks. Moving on now to emergency situations. An emergency is a serious or dangerous situation that is anticipated or unforeseen that requires immediate action. Some requirements, such as the requirement for consent, are exempt when the use of the restrictive practice is considered an emergency. If a provider uses a restrictive practice in an emergency, the provider must, as soon as practical after the restrictive practice starts to be used, inform the restrictive practice's substitute decision maker about the use of the restrictive practice, and ensure that the 7 key points, so starting from the top here, immediate action, relevant behaviours, following right down to additional advice and support, are followed and implemented in the client's care and services plan, so clearly documented. A behaviour support plan should be in place for every single client who exhibits behaviours or concerns or change behaviours, or who has restrictive practices considered, applied, or used as part of their care. So this should include assessments of behaviours, identified triggers, successful or unsuccessful alternative strategies, use of restrictive practices after trying alternatives, evidence of consumer consent or substitute decision maker consent, in addition, availability to staff for ongoing care informed by the plan. So next, I'm actually going to share with you 2 case studies. The first, it delves into the complexities of providing care to individuals with unique medical needs, particularly in the face of sudden medical emergencies. This scenario revolves around John. So John Doe, he's a 45-year-old individual with epilepsy. He has a history of strokes and his support requirements, they demand vigilance and proactive intervention. As John was being transported from a medical appointment back to his residence, fate dealt a challenging hand. In the midst of the journey, he was seized by a severe epileptic episode, leading to a perilous situation. John, agitated and disoriented, he attempted to open the car door while the vehicle was in motion, endangering not only his own life, but also the safety of others in the vicinity. In the heat of the moment, the support worker faced a crucial decision: how to ensure John's safety without compromising his autonomy. Employing a restrictive practice, the support worker engaged the child lock on the car doors and gently restrained John to prevent further attempts at escape. This immediate action, while necessary, brought to the fore a myriad of legal and ethical considerations. So within the legal framework, the NDIS mandates the use of restrictive practices only as a last resort, ensuring that they are the least restrictive option and in the best interest of the individual. State legislation, such as in New South Wales, for example, further stipulates the necessity for documented behaviour support plans, except in emergency situations. Ethical guidelines anchored in respect for autonomy and the duty of care guided the support workers' actions. While autonomy is paramount, so too is the duty of care to prevent harm, justifying the temporary use of restraint in this instance. Following the incident, immediate actions were taken. Medical attention was sought to manage John's seizure, while formal reporting requirements, including notifying the NDIS Commission and internal documentation, were fulfilled. Post-incident, a comprehensive review ensured prompting enhancement to John's behaviour support plan, and strategies were devised to manage seizures during transport, including staff training on non-restrictive interventions and the implementation of safety features within the vehicle. Furthermore, staff received additional training to navigate the complexities of epilepsy management, while psychological support was extended to address any emotional toll incurred. Integral to this process was also the involvement of John and his family, ensuring their voices were heard and their perspectives integral to the decision-making process. So in conclusion, in this case study, while the use of restrictive practices was necessitated by the urgency of the situation, it underscores the imperative of continuous evaluation and improvement in support strategies. Through adherence to legal requirements and ethical standards, we safeguard not only the rights, but also the dignity and well-being of individuals like John, ensuring that their journey towards independence is one guided by compassion and respect. So reflecting on this case study of John, think about what type of restrictive practices were evident. Did you get physical restraint and environmental restraint? If so, you were spot on. So next, now we have another case study. So we encounter Alice Smith, a 35-year-old individual with moderate intellectual disability and epilepsy residing in a SIL facility. Alice's family, like many others, grapples with concerns about her safety, particularly during nighttime seizures. Their proposed solution? The installation of surveillance cameras within the SIL residence to monitor her well-being and ensure timely assistance if needed. As we navigate through the legal and ethical landscape together surrounding this request, we encounter a myriad of considerations that warrant careful examination. First and foremost, the legal framework governing privacy rights and surveillance practices in Australia sets the stage for this analysis. So Australian privacy laws, including the Privacy Act, it dictates the collection, use and disclosure of personal information, including video recordings. Moreover, state and territory laws such as the Surveillance Devices Act 2007 in New South Wales places restrictions on the installation and use of surveillance devices without consent. Within the NDIS framework, the rights of individuals with disabilities to privacy and dignity take centre stage. Surveillance, if implemented in a manner that restricts autonomy or privacy, it can be considered a restrictive practice subject to authorisation and regular review. Ethical guidelines further underscore the importance of respecting privacy, obtaining informed consent, and exploring less intrusive alternatives before resorting to surveillance measures. So as we weigh the benefits against the risks and challenges of installing cameras in Alice's residence, we recognise the potential for enhanced safety and peace of mind for her family. Yet, we must also acknowledge the significant privacy infringement that continuous surveillance entails, as well as the complexities of obtaining informed consent from all residents and staff. So to navigate these legal and ethical considerations effectively, a comprehensive approach is imperative. Consent must be obtained transparently with clear communication regarding the purpose, extent, and locations of surveillance. Privacy safeguards, including limited access to footage and robust data security measures, must be implemented to protect against unauthorized access or breaches. Furthermore, the development of a behaviour support plan is essential, outlining the necessity for surveillance and ensuring it is the least restrictive option for ensuring Alice's safety. This plan must be approved by relevant authorities and subject to regular review to ensure ongoing compliance and effectiveness. So another good example for many considerations to be thought about. Reflecting on this case study of Alice, so this particular restricted practice, this was an environmental restraint. Okay, so Astrid will now uncover reportable incidents in home care services.
Thanks, Martina, for those great examples. As most of you would know, the Serious Incident Response Schemes, or SIRS, was brought in December 2022 and to apply to in-home aged care. The Aged Care Commission has provided far more guidance than the NDIS Commission about how to implement, respond, and manage an incident management system. So even if you do not actually provide aged care, it is a good idea to familiarize yourself with the aged care requirements because it is quite thorough. What is a reportable incident? So basically, it's the unreasonable use of force, unlawful sexual contact or inappropriate sexual conduct, psychological or emotional abuse, unexpected death, stealing or financial coercion, neglect, inappropriate use of restrictive practices, and missing consumers, which has occurred, is alleged to have occurred, or is suspected of occurring to a person receiving aged care. So it is if you can see, it's a little bit broader than the NDIS one because it also includes what it is suspected of occurring. You can report through the My Aged Care Provider portal, and if you are an approved provider, you are also responsible for the actions of your brokered services. So if you're providing services by a brokerage system, you have to make sure that the other providers that are reporting to you are performing services under your authorization, are reporting the incidents to you so that you can report them to the Commission. It is interesting to see that there is clear guidance in the aged care documents about what to do if someone refuses care. What if someone's injured and they won't let you call the doctor, for example? If the person has informed decision-making and they can make their own signatures and they can make their own decisions, it is not a reportable event to the Aged Care Commission. However, it should be recorded in your incident management system why they refused the care, why you think they refused the care, which may be different, and what you have done to address the risk. Did they try and find out why they refused medical care? Were they concerned about the hospital? Didn't they want to see a particular doctor? And that you took action to try and mitigate and address the refusal. And the other thing that you would need to do, and this applies to both aged care and NDIS providers, is to make sure that your organization has what is known as a safety culture, that your staff feels comfortable and safe in reporting incidents to you, that they will not be victimized, that they will not be performance managed if something goes wrong. And how you create a safety culture, it depends a lot on basically how management treats reportable incidents, how you respond when an incident occurs, and how you can collaborate with your personnel to make sure that they feel safe to respond to future incidents. You will be able to provide training as well as giving your staff the confidence to go into work, know when abuse is reporting, and that they can freely speak to you. When you also have to be aware, same as for NDIS, that you have to respect people's privacy and confidentiality, and that includes if there are witnesses or there are third parties there, before that you can disclose their information. But generally, there is an exception under the privacy principles for emergencies or when someone is at risk of harm, but best practice is always to obtain consent. I'll pass that on to Martina now to discuss the restrictive practices in home care.
Thanks, Astrid. So on this particular slide, we've got some good examples here that highlight what are reportable inappropriate use of restrictive practices versus examples of what is not a reportable inappropriate use of a restricted practice. You can also see there's a particular QR code here. So this QR code, this is relevant if you are in residential and/or flexible care, and this will take you to a fact sheet on appropriate use of restricted practices. So one popular question that does pop up is, what happens when an incident is reported? Well, it's the Aged Care and Quality Commission who assesses reportable incident notices to determine the type of response required. The Commission has the power to take action to address non-compliance with provider responsibility. So this includes issuing compliance notices for suspected non-compliance with CERS obligations. So moving on now to the next slide, we're going to be looking at broader reporting obligations. So you should take appropriate steps to protect the person's health, safety and well-being. This includes raising concerns with their loved ones. It could be reporting it to the police and/or contacting the Australian Human Rights Commission. If you're in any doubt about whether an incident is of a criminal nature, make the report to police. Police are the appropriate authority to investigate and identify whether an incident may involve criminal conduct. Similar to the NDIS, you may also have additional obligations to report criminal abuse to the police. So whistleblower protections, there are limited whistleblower protections in the current Act, and these protections are limited to incidents under CERS. The new Aged Care Act, it proposes to expand these protections in the aged care sector. Section 96 of the new Act, it actually says that there is a condition of registration that providers must maintain a whistleblower policy and complaints and feedback mechanism. There is also prohibited from victimisation or discrimination against a person for making a complaint or giving feedback. So if this is relevant to you, very important to make sure that you've got these policies in place. Moving now to other reporting requirements in aged care. So approved aged care service providers are required to submit a quarter financially report. This report, it was introduced from the 1st of July 2022 as part of broader initiatives to improve financial reporting transparency and also to strengthen prudential compliance for approved aged care providers. What you report in the QFI, it depends on the type of service you deliver. So residential aged care services must complete viability and prudential compliance questions, year-to-date financial statements, labour cost and hours at the facility level, in addition to quarterly food and nutrition reports, whereas home care providers, for example, must complete viability and prudential compliance also, year-to-date financial statements also, whereas the home care labour costs and hours and the total number of hours as well. And there are 5 parts to the quarterly financial reporting. So if you do require more information on this, feel free to reach out directly and happy to assist with that. Each aged care home also receives an overall star rating and a rating against 4 subcategories. So these 4 subcategories, it's the resident's experience, compliance, staffing, and quality measures. And you can search and view star ratings for each aged care home using the My Aged Care website with the Find a Provider tool. So now next we've got the aged care quality standards. So these ensure that the care and services a provider delivers, that they are safe, they're high quality, and they meet the needs and preferences of the people under the service provider's care. So Australian government funded aged care providers must show that they meet the quality standards. How you demonstrate this may depend on factors such as the size and structure of the service. And as you can see in this particular slide, there are currently 8 quality standards, and with the changes that are proposed soon to come, these standards will also be changing. I'll hand over to you now, Astrid.
Thank you, Martina. So just to wrap up, if you're a provider in aged care, NDIS, or both, you have to make sure that you're fully across the legislation in mandatory reporting, but also that you are aware of the legislation at the state level. You may also need to report incidents to the police. And in some circumstances, it is actually a crime to not report a criminal offence in some states. So getting good legal advice or regulatory advice on your mandatory reporting obligations and how to do your incident management system is really important to make sure your services go smoothly. Just briefly on upcoming legal challenges, as probably all of you know, there is a new Aged Care Act, but we don't actually have a specific date for when this will be implemented. There are many, many changes happening with the NDIS, with a proposed bill in front of Parliament, which is currently being hotly debated as we speak. We are staying abreast of the changes and will be communicating them by e-blasts and on my LinkedIn. So this concludes the main part of our webinar. You may find this publication useful about our NDIS service agreement, fact sheet. And you might also be interested in our next seminar, which is tips for sponsoring overseas workers for NDIS and aged care. While we're waiting for the questions to come in, I'll just take a minute to tell you about LegalVision's membership. By becoming a LegalVision member, your business gets unlimited access to our full team of 100+ specialist lawyers, which means we don't only have the experience in NDIS, we also have experience in corporate law, IP law, disputes, employment. As you all know, the Shads Award is extremely complicated. And we do have a team of lawyers that specializes in that. It's like having your own in-house counsel for a fraction of the cost. We also have a dedicated service for in-house teams known as our desk extension, where we can take some things off your desk and help you meet your legal requirements. If you want to learn more about our membership or desk extension, please request a free consult, and one of our lawyers will jump on to discuss this with you. Here's some of the questions that are coming in.
All right, so I might just jump in there, Astrid. So there's one particular question. It's come through from David. So David, thank you very much for your question. Can a spouse of a participant install a CCTV system that also includes their bedroom area for the purposes of monitoring support workers? We went through that particular case study, which I'm glad we did because it's nice and relevant for your question, really highlighting the different considerations that have to be thought about in terms of surveillance. So I guess the main one that does pop up in this particular scenario, it's having that consent. So consent of the organisation, the support workers, and that would make relevance to specifically the bedroom, but there would have to be a clear guideline that outlines where the surveillance would be covered, who would have access to the footage and so forth. So the consent is probably the main key factor here that would relate to whether they could or not. And Astrid, I might get you to cover on the legalities as well. I guess depending on the Privacy Act and locations and things too.
Right, and that's also very much of a state dependent. So not only there are privacy implications from having the workers in the house, but from an OHS obligations, what's called worker surveillance, because the cameras used by the client or consumer would also be capturing how the worker is working. And that will vary from state to state. We'll need to address it depending on the state and the vulnerability of the participant.
Brilliant. Thanks, Astrid. I hope that clarifies your question, David.
And I think that also answers Caitlin's question in relation to the worker rights. Basically, Caitlin, generally in most states, the workers would have to be informed that they were being under surveillance, under camera. And whether this was legal or not depends again on the state. I might take Jerry's question now about whether all restrictive practices authorized by Safeguards Commission or any other departments. This again depends on the state. For example, New South Wales is a separate department that deals with the authorization of restrictive practices. A behaviour plan will have to be lodged to the NDIS Commission, but then you may or may not need authority depending on the state level. And if you're in aged care, that's again different. The question now From Fiona about the restrictive practice of a playgroup for young children who attend with their parents and they close the door to the hall. This is not generally seen as a restrictive practice because it is age appropriate, but it could be under certain circumstances if the child was actively trying to get out and the door was locked to keep them in. But generally speaking, when there is a young child, and most 3-year-olds in most kindergartens, you will have the child lock gates to keep children safe who wander away. So generally speaking, this in itself would not be a restrictive practices, but it could potentially be depending on other circumstances.
So I might jump into Vanessa's question relating to if you suspect an NDIS participant has been abused or assaulted by someone who is not an NDIS provider, do we need to obtain the participant's consent to report it to the police? I guess the most important aspect in this scenario is if there's abuse and you're seeing it, it should be reported. So consent is not required if you do see it in this position. So if that is occurring and you are seeing it, report it immediately.
And the next question that we have is about conflicts of interest. This is not really relevant to what we were talking about today. I'm happy to talk to the person who put this question on a free consult afterwards. But generally speaking, if there is a conflict of interest that you think is affecting the participant, which in the scenario given might be, and it's leading to coercion or abuse, then that would definitely be a reportable event. In some states, there is also an additional obligation on providers to report other providers if they are breaching the law, regardless of whether there's harm to the participant or not. In relation to the duty of care responsibilities, if a client requires urgent medical care and refuses medical care, we've covered that under the aged care because that's already covered under the aged care. The same thing would apply for NDIS. There just needs to make sure that you understand that there is a dignity of risk and that some participants of that legal capacity for their own reasons may deny themselves medical treatment.
So there is another question that's come up. I'll quickly answer this again. Who pays for additional training for staff? So any training should be undertaken by the service provider. And that really should fall part of your continuous improvement initiative. So whether that's in aged care or under NDIS, you should ideally have a continuous improvement register, and there should be mandatory training. And particularly with all the upcoming changes in terms of policies and the Act, very important that you've got those strategies in place so that all staff are equipped and have the knowledge that is required.
I'm just going to follow up to Lee's question. I'm just going to follow up to Vanessa's question. Lee, it depends. It depends on whether the age of the participant, because the age makes whether it's a child sexual abuse, in which case in most, I think all states, this will be a reportable event. Whether you have to report to the police or the child abuse hotline may depend on the state. If the person doesn't have legal capacity, you definitely have to report it, even if you suspect it, and the police will investigate. If the person has legal capacity and does not want the abuse reported, then it's slightly more complicated. Aged care has different rules to NDIS on this. As Martina said, usually in case of doubt and there is a crime, you should report it. If the person, you've spoken to the person and they are clear they do not want it reported, they have legal capacity, you may need to put it into your incident management system, and you may need to report it to the NDIS Commission, but not necessarily to the police. So this would be a case-by-case scenario, and there are too many factors for us to actually adequately cover this in a talk, but more than happy, Martina or I would be more than happy to talk to you about this some more offline. One last question, and from Joe. If you see that the support worker has disturbing behavior, if you think this is likely to cause harm to the NDIS Commission, to her an NDIS participant or aged care participant, you may be able to report it because there is a potential for harm to occur. There is a banned list in Victoria, not in other states. And in terms, when you contacted the service provider, she advised that the worker was no longer employed. This is kind of difficult to manage because currently, apart from Victoria, and Martina, just correct me if I'm wrong, I don't think there are any other ban, apart from aged care, but under NDIS, there is no ban list per se of workers, unless you goes to the federal court and the NDIS commission actually bans the worker from providing services. So you can report it to the NDIS commission. Whether they will do anything about it is unlikely, but it may be on their file so that if there is another complaint, it will be quicker for the worker to be banned because there has been a report already filed.
Yep. No, spot on, Astrid. And I'd probably just say on this note as well, in the relevance of whether somebody actually is still employed in the organisation, really important that you've got clear social media policies as well outlined, so that I guess there's no overlap between dual roles and so forth. So professional and personal capacity is separated.
David, in relation to your employment question, our employment team will be more than happy to answer this for you. This is a Shaz award. I don't do employment law, but please feel free to book a call. And I think we need to wrap up. I'm getting the please wrap up from our backend team. So thank you for joining us today. And it was lovely meeting all of you.
We hope to see you again. Thank you so
Thanks,
much,
Martina,
everybody.
Thanks, bye.
Thanks, Astrid. Bye.